at the stage of entering into the contract, one party was definitely fraudulently inducing the other party, who is managed by private individuals, like in case of Nigeria. Second category of fraud or corruption can arise during the implementation of the contract. The contract per se is a valid contract without being tainted by any fraud or corruption, but during the execution of the contract there was a collusion, there was a corruption and a fraud played by one party. As a result, the contract could not be completed. Third and most important, and let us not turn our eyes from that, the fraud committed during the arbitral proceedings itself, when the arbitral award is the result of the fraud. Now, when we are entering into an arena which is not statutorily recognized or statutorily regulated, one more question would arise. Take, for example, a contract between a public sector undertaking and a private company. Public sector undertaking obviously acts through individuals, and individuals are amenable to pressure, amenable to fraud, amenable to corruption, amenable to collusion, etc., etc. There is a contract entered into which is tainted by fraud or corruption. Let us take an example that even the execution of the contract is also tainted by fraud and corruption, as a result of which the party suffering the fraud and corruption would say that we would feel more safe in going and getting our dispute adjudicated before a competent court of law rather than going before a party-chosen arbitral tribunal. And a private party approaches the competent forums. In India, it is the High Court or the Supreme Court in case of international arbitration, and it may be different in case of other domestic laws. Can the party opposing arbitration raise the ground of fraud to oppose appointment of an arbitral tribunal? These are the questions which will have to be answered either by the evolving jurisprudence, by honorable courts, or by making a statutory provision. Friends, I can share that our government, Indian government, came across a very huge case of fraud where the contract was entered into fraudulently, the execution was fraudulent, and the award was passed. I will not take all the stages. Ultimately, the government of India had to take a decision to present a bill before the Indian Parliament amending Section 34, which is the provision for challenge to an arbitral award, and now fraud is a valid ground for challenging the arbitral award. I believe that's what the position in England also is. Fraud is a ground. But suppose in a case where parties are governed by law of either law which is neither an Indian law nor English law, some other law, this is not a ground of challenge. Therefore, in cases of arbitral contracts or contracts containing an arbitration clause, what is most important, according to me, is two things. One, the drafting of the contract itself, which is in many a times found to be lacking when we deal with the arbitration proceedings. And second, absolute impartiality and integrity of the arbitral tribunal. Unless and until the second part is secure, the question all of us will have to ask ourselves is, can we trust a forum created by us with power to adjudicate something which is not even pleaded? It's a question very difficult to answer, but will have to be answered because we have already entered into an arena where fraud and corruption is a part of either contract making, execution, arbitral proceedings, or further proceedings. whatever my Lord the Chief Justice and my Lord Justice Vikram Nath has said is as per our constitution binding on me, and therefore I concur with whatever his lordships have said.
We decide what you argue.
So I just presented a lawyer's perspective while fully, respectfully endorsing what his lordships have said. I really thank both Mr. Dharmadhikari and Mr. Singh that I was given an opportunity to sit on the same dais as the luminaries who are present here. And I thank all of you for giving me a very patient hearing. Thank you so much.